Hello and welcome to Daily News Simplified, an answer to what, why and how of newspaper reading from UPSC Civil Services examination perspective. Today we will be taking up the New Delhi edition of the Hindu newspaper dated 21st December 2022. The news to be taken up has been displayed on the screen and the timestamp has been provided in the YouTube description. Now along with this, you should also subscribe to the PSIR test series and its description has been provided in the link below. Now let's start our discussion with this news appearing in the editorial section on page number 6. And this news highlights about increasing interstate boundary disputes between different states. Now this news particularly highlights about the boundary disputes between Maharashtra and Karnataka because of the disputed area of Belagavi or Belgaum. Now this news particularly says that interstate disputes resolution lies in a political culture respectful of diversity. So this editorial basically highlights about the growing disputes between Maharashtra and Karnataka, as the Chief Minister of Karnataka and Deputy Chief Minister of Maharashtra both are at crossing swords, especially with respect to the sensitive area of Belgaum or Belagavi. Now this problem with respect to Belagavi or Belgaum arose because prior to the State Reorganization Act of 1956, this particular area of Belagavi was in the Bombay Presidency. But after the State Reorganization Act of 1956, the area of Belagavi was transferred to the state of Karnataka, and this has been the reason of dispute ever since. Now, based on the earlier areas of Bombay Presidency, Maharashtra has claimed that around 865 villages of Karnataka should be part of Maharashtra, and these includes Belagavi, which earlier was Belgaum, Karwar, and also Nipani. Whereas on the other hand, Karnataka has not only rebuffed the claim of Maharashtra, but rather has counter-claimed areas in Kolhapur, Sholapur and Sangli district of Maharashtra. Now apart from this, there have been border disputes also along the boundaries of Maharashtra and Telangana. Now in order to resolve this dispute between Maharashtra and Karnataka, the government in 1966 constituted the Meher Chand Mahajan Commission. Now the Mahajan Commission did not agree to the claim of Maharashtra and recommended that Belagavi should remain part of Karnataka and should not be transferred to Maharashtra. Now other than this, the Mahajan Commission also recommended that 247 villages or places including Jat, Akalkot and Sholapur to be made part of Karnataka. Now this further infuriated the state of Maharashtra. Whereas with respect to Maharashtra, the commission suggested that 264 villages or places including Nipani, Khanapur and Nandgarh to be transferred to Maharashtra. Now as you can imagine that both states of Maharashtra and Karnataka did not agree to the recommendations of the Mahajan Commission, and in response, the state government of Maharashtra filed a petition in the Supreme Court way back in the year 2004 under Article 131 of the Indian Constitution. Whereas the state of Karnataka contends that only Parliament under Article 3 of the Indian Constitution can decide the state borders and not the Supreme Court of India. So these two constitutional provisions becomes important with respect to resolving interstate boundary disputes. Now another reason for this dispute apart from the political reason of State Reorganization Act 1956 is that in the areas of Belagavi, which presently is in Karnataka, the population speaks Marathi language. So based on this linguistic closeness, the state of Maharashtra claims over Belagavi. And this dispute between Karnataka and Maharashtra is not an only dispute, as there are a number of interstate boundary disputes, particularly in the northeast region. And one of the major reasons is division of states through various reorganization acts of that respective states. And overall, we can say that whenever states are reorganized on linguistic lines or on any other lines, including administrative lines, that is, when states are reorganized and new states are created, there are bound to be interstate boundary disputes. And these boundary disputes needs to be resolved. Now, if we talk about the state of Assam, then successive reorganization of state of Assam leading to creation of different states such as Arunachal Pradesh, Mizoram, Tripura, Manipur, Meghalaya has further increased and also intensified interstate boundary disputes. So other than tussle over Belagavi, even Punjab has claimed the union territory of Chandigarh. So it highlights that the Punjab Reorganization Act of 1966 resulted in the formation of a new state of Haryana, which was carved out from the state of Punjab, and it also resulted in formation of Union Territory of Chandigarh and also transfer of certain territory from Punjab to Himachal Pradesh. Now since then, Chandigarh has been a joint capital of both Punjab and Haryana. However, now the Punjab government has passed a resolution urging the central government to transfer Chandigarh to the state of Punjab. So this has again intensified claim over Chandigarh by the Punjab government. Now if you talk about various interstate boundary disputes in the northeastern states, then we have witnessed Assam-Mizoram border dispute, Assam-Arunachal border dispute, and recently the Assam-Meghalaya border dispute. Now regarding these disputes, one needs to understand the successive division of Assam which took place over a period of years. So it says that Assam has boundary disputes with most of or all the northeastern states that were carved out of it, as these divisions were based on administrative decisions where local tribals were not consulted. Now this is one of the major reasons of various boundary disputes which the state of Assam has with its neighboring states. So it highlights that while Nagaland became a state in 1963, Meghalaya first became an autonomous state in 1970 and a full-fledged state in 1972. Now Arunachal Pradesh and Mizoram were separated from Assam as UT in 1972 and then as states in 1987. And none of these newly constituted states agreed upon the political division of the states because they contend that their tribal stakeholders were not consulted with respect to this political arrangement of state boundaries. And these newly constituted states also claim that disputed areas were traditionally under the control of tribal chieftains who were not consulted before demarcating boundaries of states. Now this is one of the major reasons with respect to the boundary disputes along the northeastern regions. Now if we talk about the Assam-Mizoram border dispute, it highlights that the dispute started after Mizoram, which was earlier part of district of Assam known as Lushai Hills, was carved out as a separate state in 1980. And the present day dispute along its boundary is because of a notification from the year 1875 derived from the Bengal Eastern Frontier Regulation of 1873, which differentiated the Lushai Hills from the plains of Kachar region, and another notification of 1933 that demarcates a boundary between Lushai Hills and Manipur. So Mizoram leaders have argued against this notification of 1933 and rather believe in the notification of 1875. Whereas on the other hand, state of Assam claims that 1933 demarcation is the final demarcation. So again, the boundary dispute is with respect to difference of understanding of political agreements or political arrangement regarding the interstate boundary agreed upon once way back in 1875 and again rearranged in 1933. So it says that Assam have claimed 1933 demarcation to be the final demarcation that demarcates a boundary between Lushai Hills and Manipur, obviously which is not agreed upon by Mizoram. And even the Assam-Arunachal border disputes dates back to 1873, having its origin in the Bengal Eastern Frontier Regulation 1873. It says that when inner line regulations bifurcated the plains and the hilly region, and this bifurcation between the plains and the hills resulted in the formation of Northeast Frontier Tracts in 1915. However, in 1951, based on Gopinath Bardoloi Committee's report, the plain areas of Balipara and Sadia foothills was transferred from Arunachal Pradesh to Assam's then Darang and Lakhimpur district. Now this transference of plain area of Balipara and Sadia foothills based on Gopinath Bardoloi Committee's report is not agreed upon by Arunachal Pradesh. Now again, Arunachal Pradesh claims that this transfer of land, which took place in 1951, was arbitrary because local tribes were not consulted. So as you can see, the importance of the consultation aspect with respect to the local tribes or local chieftains becomes one of the major reasons of increasing boundary disputes, especially in the northeastern states. Whereas according to the state of Assam, the demarcation done in 1951 is constitutional and final. So basically, they do not agree upon the various political arrangements which have taken place in the past. And even with respect to the state of Assam and Meghalaya, an agreement was reached upon in March 2022 to settle the disputes along the borders, but presently violence have erupted across the borders, and the recent firing and violence along the borders may derail the upcoming talks of settlements on boundary disputes. So overall, if we talk about reasons for interstate boundary disputes, then we can say that successive reorganization of states resulted in continuous change in their boundaries, failure of forums such as Interstate Council, which is constituted under Article 263 of the Indian Constitution, and Zonal Council, constituted under State Reorganization Act of 1956, has failed to resolve these boundary disputes. Non-compliance of recommendations of various committees and reports. For example, the Mahajan Commission was tabled in the Parliament, but no serious discussion took place. Next, non-compliance of judicial or administrative orders, as either they are not abided by or an appeal is then filed in the higher benches. The next is failure to reach an amicable or peaceful solution on border disputes. And here we can cite the example of Assam-Meghalaya Agreement, which was agreed upon in March 2022, but still violence erupted in the border areas. And also the fact that these border issues at times are used for political gains by respective state government. So these can be said to be some of the reasons for interstate boundary disputes. Now coming to the impact of these increasing border disputes, then we can say it affects federal relations between states. It results in economic blockade, at times leading to disruptions in supply chain and logistics. This also leads to aggravated violence and destruction of public property, as we have witnessed in different border disputes, especially along the northeast region of Assam, Mizoram and also Assam, Meghalaya. It obviously leads to disturbance in public order, especially along the interstate border areas or boundary areas. Such disputes may lead to increasing demand for formation of new states, and also the fact that regional identity takes center stage. For example, demand for Bodoland or Nagaland. So these can be said to be some of the impacts of increasing border disputes. So the question is how to resolve these increasing interstate boundary disputes. And here the National Commission to Review the Working of the Constitution way back in 2002 suggested that there are following mechanisms which exist within the constitutional framework to settle these interstate disputes. And these mechanisms include judicial mechanism under Article 131 of the Indian Constitution, which the Maharashtra government has claimed, solving dispute through Interstate Council under Article 263 of the Indian Constitution, Parliament altering the boundary under Article 3 of the Indian Constitution, which the state of Karnataka has referred to, and there are also disputes with respect to sharing of river water. So for this, Article 262 provides for a mechanism for resolving interstate river water disputes, under which the Parliament has enacted the Interstate River Water Disputes Act of 1956. So let's go through these constitutional provisions one by one. So Article 131 mentions about the original jurisdiction of Supreme Court. So it says that subject to the provision of this constitution, the Supreme Court shall to the exclusion of any other court have original jurisdiction in any dispute between Government of India and one or more states, between Government of India and any state or states on one side and one or more other states on the other, and between two or more states. So we can say that Supreme Court does have original jurisdiction with respect to resolving boundary disputes with respect to this provision, that is original jurisdiction between two or more states. Now coming to Article 3 of the Indian Constitution, it mentions about formation of new states and alteration of areas, boundaries or names of existing states. So it specially mentions about altering the boundaries of different states. And Article 3 empowers the Parliament. So it says that Parliament may by law form a new state by separation of territory from any state or uniting two or more states, or parts of states, or by uniting any territory into a part of state. The Parliament can by law increase the area of any state, diminish the area of any state, alter the boundaries of any state, and alter the name of any state. So again, specific provision has been provided under Article 3 with respect to altering the boundaries of any state. And if we go through the provision of Article 263, it mentions about provisions with respect to an interstate council. So it says that if at any time it appears to the President that the public interest would be served by the establishment of a council charged with the duty of the following. So these are the constitutional duty which the interstate council is supposed to perform. These are inquiring into and advising upon disputes which may have arisen between states. So this also includes interstate boundary disputes, investigating and discussing subjects in which some or all of the states or union and one or more of states have common interest, or making recommendations upon any such subject, and in particular, recommendations for better coordination of policy and action with respect to that subject. And for this purpose, it shall be lawful for the President by order to establish such a council and also define the nature of duties to be performed by such council. Now, till the year 1990, the Interstate Council was not constituted, and based on the recommendations of Sarkaria Commission, the Government of India constituted the Interstate Council. So this is the presidential order constituting the Interstate Council issued by the Ministry of Home Affairs, and it states that the following order by the President is published for general information. And it mentions about constitution of an interstate council under Article 263 of the Constitution. So it says that the President hereby makes the following order, namely, this order may be called the Interstate Council Order 1990, and it shall come into force at once. Composition of the council: there shall be an interstate council consisting of the Prime Minister, Chief Minister of all states, Chief Minister of Union Territories having a legislative assembly, and the administrators of UTs not having a legislative assembly, and 6 ministers of cabinet rank, and Prime Minister is the chairperson for Interstate Council. So a permanent Interstate Council has been constituted through a presidential order in 1990 based on the recommendation of Sarkaria Commission. Now this becomes an important aspect from your prelims perspective. Now at the start of the discussion, we discussed about the State Reorganization Act and how the State Reorganization Act has led to increasing boundary disputes between states. So on this note, let's go through some of the important facts with respect to the State Reorganization Act of 1956, particularly from your prelims and mains perspective. So it highlights that the first States Reorganization Commission was constituted in 1953, appointed by the Prime Minister Jawaharlal Nehru. The State Reorganization Commission was headed by S. Fazal Ali and had 2 members, namely K.M. Panikkar and H.N. Kunzru. Now, the Constitution's 7th Amendment implemented states reorganization and also added Article 350A to the Constitution, which facilitates for instruction in the mother tongue at the primary stage of education to children belonging to linguistic minority groups. And the States Reorganization Act of 1956 also provided for the following. It amended the 1st and 4th schedule of the Indian Constitution. It provided for provisions of high courts for the newly constituted states. It provided for the constitution of zonal council, for the delimitation of constituencies in different states. It provided for the provision of all India services for the newly constituted states and also services under the State Public Service Commission. So these are some of the important facts which you should remember, especially from your prelims perspective with respect to the States Reorganization Act of 1956. Now this topic of increasing interstate boundary disputes and also possible resolution becomes an important topic, particularly under GS paper 2 with respect to issues and challenges pertaining to the federal structure and also with respect to important features and amendments of the Constitution of India. Now let's take up this article appearing on page number 7, and this article says that profound ramification of one amendment, and this one amendment which this article discusses is regarding section 81J of RTI Act. So basically the proposed Digital Personal Data Protection Bill of 2022 intends to amend this particular provision of RTI Act, namely section 81J of RTI Act. So this article highlights about 2 important aspects. First is regarding amendment of section 81J of RTI Act through the proposed Digital Personal Data Protection Bill of 2022. And second, this article effectively talks about the Data Protection Board. Although this article has referred Data Protection Board, which is the term which has been used in Digital Personal Data Protection Bill of 2022 as DPAI. So this article has questioned the independence of Data Protection Board and has also suggested that since members of Data Protection Board will be appointed by the central government, hence it also violates one of the important Supreme Court judgment of Madras Bar Association case series, which basically suggested that selection committee to appoint members of tribunal should not be dominated by members of executive. So in this article, let us understand these 2 important aspects which has been highlighted here. And this topic gets covered under GS paper 2, particularly with respect to governance and also with respect to the functions of parliament, government policies and interventions, and also important aspects of governance, transparency and accountability. And it also gets covered under GS paper 4, particularly with respect to ethics and probity in governance. Now section 81J of RTI Act as of now disallows disclosure of personal information. So any personal information about an individual shall not be allowed if it fulfills any of these two conditions. So the first condition highlighted here is that if it has no relation to any public activity or public interest. Now it's important to understand the concept of public activity or public interest. Now the Digital Personal Data Protection Bill of 2022 has defined public interest. So it says that public interest means in the interest of any of the following: in the interest of sovereignty and integrity of India, in the interest of security of the state, friendly relation with foreign states, maintenance of public order, preventing incitement to the commission of any cognizable offense. Now, cognizable offenses are serious offenses in which the police can arrest without any warrant, and preventing dissemination of false statements or facts, that is, false information or fake news. And secondly, personal information can be denied to any person if it causes unwarranted invasion of privacy of the individual. So, in the present RTI Act, under section 81J, information pertaining to an individual can be denied or cannot be provided if it has no relation to any public activity or public interest, and if it causes unwarranted invasion of privacy of the individual. So basically, section 81J of RTI Act effectively secures or protect our personal information. Now, under the new Digital Personal Data Protection Bill of 2022, these two aspects or these two security or protection with respect to personal information has been omitted. And it is because of this the author in this article suggests that removing these two provisions or security with respect to disclosure of personal information may impact freedom of speech and expression of an individual. So if we go through the exact wordings of section 81J of RTI Act, it says exemption from disclosure of information. So it says that there shall be no obligation to give any citizen information which relates to personal information, the disclosure of which has no relationship to any public activity or interest, or which would cause unwarranted invasion of privacy of the individual, unless the Central Public Information Officer or any other state public information officer or any other appellate authority is satisfied that disclosure of such personal information serves larger public interest. So this is the protection which as of now exists under section 81J of RTI Act. And these two provisions or these two security are proposed to be omitted under the Digital Personal Data Protection Bill of 2022. So it says that clause J of subsection 1 of section 8, basically section 81J of RTI Act, shall be amended in the following manner. It says that the words, the disclosure of which has no relationship to any public authority or interest, or which would cause unwarranted invasion of privacy of the individual, unless the public information officer of the center or of the state or any appellate authority is satisfied that larger public interest justifies the disclosure of such information, shall be omitted. So the Personal Data Protection Bill, by amending section 81J of RTI Act, intends to remove these security with respect to disclosure of personal information. Now let's discuss the second aspect with respect to dominance by members of executive in the tribunal. But first of all, let's go through the important Supreme Court judgment so as to better understand the concern highlighted in this particular article. So the Supreme Court of India has highlighted certain concerns, especially with respect to dominance by members of executive with respect to selection committees to select members of any tribunal. And in this regard, the Supreme Court, in the very famous judgment of Roger Matthews versus South Indian Bank and others, have highlighted various aspects which were violated. So the first aspect highlighted is violation of judicial independence if the selection committee is dominated by members of executive while appointing members of tribunal. So here the Supreme Court declared that the rules framed under the Finance Act 2017 were unconstitutional for being violative of principles of independence of judiciary as under these rules, there was dominance by members of executive in the selection committee. The second point highlighted was that since number of members from the executive or appointed by the government were more, hence the Supreme Court suggested that it was a deliberate attempt to keep the judiciary away. So the Supreme Court held that search cum selection committee to appoint members of tribunals was an attempt to keep the judiciary away by the executive from the process of selection and appointment of members, vice chairman and chairman of tribunals. The third point highlighted was with respect to the aspect of bias and prejudices on behalf of these members appointed by the government. So the court held that executive is a litigating party in most of the cases which appears before various tribunals and hence cannot be allowed to be a dominant participant in tribunal appointments. So the aspect of bias was also highlighted. The next point highlighted was that members of tribunals were mostly from central government. The court observed that apart from NCLT, that is National Company Law Tribunal, the selection committee for all other tribunals was made up either entirely from personnel within or nominated by the central government or comprised a majority of personnel from central government. And the last point highlighted was that most selection committee had only one judge. So clear dominance by the members of executive. And based on this, the Supreme Court in the Madras Bar Association series case, in order to ensure independence of tribunal, suggested that the selection committee should comprise the following: Chief Justice of India or his nominee as chairperson with a casting vote, so 1 member of the judiciary, a senior judge of the Supreme Court or Chief Justice of the High Court, so another member of the judiciary, and 2 secretaries in the Ministry of Finance and Ministry of Law and Justice respectively, so 2 members from the executive. So we see that there is a balance between members of judiciary and also members of executive. So it highlights that subsequent Constitution Bench decisions in Madras Bar Association case of 2014, Roger Matthew case of 2019, and the decision of Madras High Court in Shamnad Bashir case have repeatedly held that principles of Madras Bar Association of 2010 are applicable to the selection process and constitution of all tribunals in India in order to ensure the independence of tribunals and their functioning. And based on this very important Supreme Court judgments, the author has suggested various concerns in this article. And the concerns highlighted are with respect to amending section 81J of RTI Act and also regarding the independence of Data Protection Board, because its members will be appointed by the government and a lot has been left on rule-making power of the central government. So the author suggests that the ratio of Madras Bar Association versus Union of India has also been ignored in the new draft bill. And also the fact that adjudicatory role of Data Protection Board may be compromised, as the members will be solely appointed by the executive or by the central government. And such appointments by the central government could undermine the overall functioning and independence of the authority. So these are some of the important concerns which have been highlighted in this particular article with respect to the Digital Personal Data Protection Bill of 2022. Now let's take up this news appearing on page number 11. And this news with respect to Rule 267 of Rules and Procedure for Conduct of Business in Rajya Sabha becomes important mainly from your prelims perspective under the section of Polity and Governance. Now this news says that Rule 267 has become a bone of contention in Rajya Sabha. Now let's understand about this rule first. So this rule is mainly used by members of opposition to debate an urgent issue, such issue which has been listed for that particular day. So suppose if the issue of inflation has been listed for a particular day, then the members of the opposition can use Rule 267 and ask the chairman of Rajya Sabha to allow discussion on this listed topic of, say, inflation. So this particular news highlights that Rule 267 of Rajya Sabha rulebook that allows for suspension of the day's business to debate an issue. So basically when Rule 267 is used by members of opposition and if it is allowed by the chairman of Rajya Sabha, then the ongoing discussion takes a back seat or the ongoing discussion is suppressed. So it says that Rule 267 of the Rajya Sabha rulebook that allows for suspension of the day's business to debate an issue suggested by a member has become a bone of contention, and not a single notice under the rule which has been moved by the opposition has been accepted in the winter session. So the opposition have been using Rule 267 and have been asking the chairman of Rajya Sabha to allow debate on certain issues which are listed for the day, but the chairman so far has not allowed Rule 267 to be used by members of opposition. The news further says that on Tuesday, 6 such notices were declined by the chairman of Rajya Sabha, prompting Trinamool Congress member Derek O'Brien to point out the precedents. So the precedent suggested that there were 11 instances between 1990 and 2016 when this rule was invoked for various discussions, and one of the discussions for which this rule was invoked was for discussion on demonetization of currency. So this news says that in this session, the members have moved notices under Rule 267 demanding debate on various issues, including India-China standoff. Now these rules of procedure and conduct of business, both of Rajya Sabha and Lok Sabha, becomes important. As you can see, a question has been asked by UPSC in the prelims of 2022. So first of all, let's go through the provisions of Rule 267 of Rules and Procedure and Conduct of Business of Rajya Sabha. Then we will take up the question asked in the prelims of 2022. So Rule 267 is basically regarding suspension of rules, and it says that any member of Rajya Sabha may with the consent of the chairman. So the consent of chairman becomes mandatory if Rule 267 is to be allowed. So it says that any member may with the consent of the chairman move that any rule may be suspended in its application to a motion related to the business listed before the council of that day. And if that motion is carried, the rule in question shall be suspended for the time being. And this application to a motion related to business basically means discussion or debate on various issues, say India-China border issue or inflation or any other issue. It further says that Rule 267 shall not apply where specific provision already exists for suppression of a rule under a particular chapter of rules. So it basically means that Rule 267 shall not be used if there are other provisions to allow debate on some other matter which has been listed for that particular day. So listing of that particular discussion for that particular day is very important. Now coming to the question asked by UPSC in the prelims of 2022. The question was, with reference to Deputy Speaker of Lok Sabha, consider the following statements. First, as per the rules of procedure and conduct of business in Lok Sabha, the election of Deputy Speaker shall be held on such date as the Speaker may fix. Yes, this statement is correct, and this has been provided under the rules of procedure and conduct of business in Lok Sabha. Second, there is a mandatory provision that election of a candidate as Deputy Speaker of Lok Sabha shall be either from the principal opposition party or the ruling party. No, there is no such mandatory provision which calls for election of candidate as Deputy Speaker of Lok Sabha to be from either principal opposition party or ruling party. Now, as a precedent, we have generally seen that the Deputy Speaker of Lok Sabha is generally from the opposition party. The third statement says that the Deputy Speaker has the same power as that of the Speaker when presiding over the sitting of House and no appeal lies against his rulings. Yes, this statement is correct. Fourth, the well-established parliamentary practice regarding the appointment of Deputy Speaker is that the motion is moved by the Speaker and duly seconded by the Prime Minister. No, it is not seconded by the Prime Minister but other Minister of the government. So the question was, which of the statements given above are correct? So correct answer here is A, that is 1 and 3 only, as statement 2nd and 4th are incorrect. So the point to be noted here is that if any rules pertaining to rules of procedure and conduct of business either of Lok Sabha or Rajya Sabha is in news, then it's important for us to know about that particular rule. Let's take up this news appearing on page number 8 in the text and context section. And this news highlights about the Kunming-Montreal agreement which has been adopted by 188 of the 196 member nations during the Convention on Biological Diversity. So this news highlights a new global biodiversity framework. And this framework has been mainly addressed to halt the sharp and steady loss or decline of biological species in the world. So the gist of this article highlights few important points. Let's go through that. It says that 188 of the 196 member governments during the Convention on Biological Diversity adopted the Kunming-Montreal Global Biodiversity Framework, or GBF, which it has been referred in the news throughout. Now this framework has set out 4 goals for the year 2050 and 23 targets for the year 2030, to save existing biodiversity. So basically this agreement aims at reducing the loss of biodiversity, including saving of degraded land and water system. Now, degraded land is such kind of land that has lost some degree of its natural productivity due to human caused processes. So the global biodiversity framework also intends to save existing biodiversity and also ensure that 30% of degraded terrestrial, inland water, coastal and marine ecosystems come under effective restoration. So it effectively talks about restoring the terrestrial and marine ecosystem to its natural productivity. Now, another important feature of global biodiversity framework is the sustainable use of biodiversity. So it does not prohibit use of biodiversity but rather call for its sustainable use and a sharing of benefits from genetic resources. It also emphasizes respect for rights of indigenous communities that traditionally protect forests and biodiversity. So another important aspect of global biodiversity framework is the fact that it also emphasizes respect of rights of indigenous communities and also their culture in order to protect the forest and biodiversity of the region. Now, in order to restore the decline in biodiversity, the framework also hopes to raise billions of dollars towards this project. So it says that by 2030, the GBF hopes to see at least $200 billion raised per year from all sources towards implementation of national action plans. Now, the aspect of funding for this particular framework may become a challenge as it highlights that in terms of international funding, developing countries should get at least $20 billion a year by 2025 and at least $30 billion by 2030 through contributions from developed countries. Now, raising finances for developing countries may prove to be difficult in order to achieve the objectives of global biodiversity framework. Now, the Kunming-Montreal Global Biodiversity Framework has set out targets for 2030. And these 23 targets include protection for degraded areas, resource mobilization for conservation of such degraded areas, and also conservation of forest in general, compensation for countries that preserve biodiversity, halting human activity linked to species extinction. So they are also trying to halt or reduce extinction of species. Next, reducing by half the spread of invasive alien species which are introduced in a new environment. Now, invasive alien species are such plants, animals, pathogens or other organisms that are non-native to an ecosystem. Now, these invasive alien species may impact the overall biodiversity of the regions in which they are introduced. Another target set out in the framework includes cutting pollution to non-harmful levels and minimizing climate change impact and also ocean acidification. Now let's also go through some of the other important facts with respect to the Kunming-Montreal Global Biodiversity Framework. So this agreement also calls upon member states to adopt biodiversity supporting methods such as agroecology and sustainable intensification. Let's understand both these concepts, and questions can be asked in your prelims examination about both these important terms. So agroecology basically promotes farming practices which mitigate climate change, that is, which helps to reduce emissions, which recycle resources, and which also prioritize the local supply chains. Now, another practices of agroecology is to work with wildlife. And here the purpose is to manage the impact of farming on wildlife, such as pollinating crops and controlling pests. And another important aspect of agroecology is to empower the farmer. So it says put farmers and communities in the driving seat. So they give power to approaches led by local people and adapt agricultural techniques to suit the local area. So again, local conditions are also important, and its specific social, environmental and economic conditions should also be looked into. Now, talking about sustainable intensification, this is an approach using innovative methods to increase productivity of the agricultural land with positive environmental and social impact So the focus is not only on improving the land degradation or improving the productivity of the land, but also on social aspects. So sustainable intensification in this regard also takes into consideration impacts on overall farm productivity, profitability for the farmers, production and market risk for the farmers in using these innovative methods to grow crops, and also the aspect of resilience as well as interest and capacity of individual farmers to adopt innovations. So sustainable intensification is not limited to only environmental concerns but also includes social concerns, the economic concerns of the farmers because the farmer is using these innovative methods to grow crops, and it also includes improving the livelihood of farmers, the aspect of equity and also social capital. Now, other key fact with respect to global biodiversity framework includes it also talks about turning cities into host of biodiversity by expanding urban green and blue spaces. Now, this can be achieved when urban planning also takes the aspect of biodiversity into consideration. So it says that urban planning should also be biodiversity inclusive as it will help to enhance native biodiversity of such urban areas, and this enhancement of native biodiversity will further improve the health of citizens living in the urban area. So it says that it will also lead to ecological connectivity and integrity and help to improve human health and well-being and connection to nature. Further, the framework also envisages that there will be access to justice and information related to biodiversity for indigenous peoples and local communities. And this will be achieved by respecting their distinct culture and rights over their lands, territories, resources, and also traditional knowledge. Now, as per the Kunming-Montreal Agreement, there are 4 goals to be achieved by 2050. And these 4 goals are with respect to maintaining ecosystem integrity and health to halt extinctions of various species, measuring and valuing ecosystem services provided by biodiversity, sharing monetary and non-monetary gains from genetic resources, and digital sequencing of genetic resources with indigenous people and local communities, and also raising resources for all countries to close a biodiversity finance gap of an estimated $700 billion. So these are the goals which are to be achieved by the year 2050. And to achieve these goals set out by the Global Biodiversity Framework, member nations needs to submit a revised and updated national biodiversity strategy and action plan in the conference which is to be held in 2024. Further, the parties to the Convention on Biological Diversity should also submit national reports in 2026 and 2029 to help prepare global reviews, and a high-level discussion on the progress review should also be held in 2024 and 2026. So these are some of the important goals which has been set by the Kunming-Montreal Global Biodiversity Framework, which is to be achieved by 2050 and 23 targets to be achieved by 2030. Now this topic becomes important both from your prelims and mains perspective under environment section under GS paper 3. Now based on our discussion, these becomes your practice question for mains. The first question is, highlight the salient features of Kunming-Montreal Global Biodiversity Framework along with challenges which the countries might face collectively in achieving the goals under the framework. This question carries 10 marks. The next question is, discuss the reasons and impacts of increasing interstate boundary disputes in India along with recent examples. Also suggest suitable measures to resolve such disputes within constitutional and other legal framework. So I hope after this discussion you will be able to attempt both these practice questions for your mains examination. With this, we come to an end to today's discussion. Thank you for watching DNS.